a great pleasure to be with you here at the end of what is our climate change month, where we've been looking at a number of issues around climate change and climate justice. And today we are going to look at climate litigation. And we're very pleased tonight to have two exceptionally talented and knowledgeable people about climate litigation who are the authors of a particular report that we will discuss soon. But today, of course, we are talking about climate litigation in the context of the post-COP26 that wrapped up in Glasgow last week. And the reports certainly from Glasgow were mixed. High expectations perhaps not able to be achieved in the current economic and COVID climate, and certainly significant criticisms and concerns were raised by people who were at COP, as also there was a number of significant issues that did not quite make it onto the agenda, and some that just barely got onto the agenda in terms of loss and damage and other issues relating to climate justice. It's also important to note that this issue of climate justice and climate litigation is in the context too of the Code Red for Humanity that has been declared by the Secretary General of the United Nations. And earlier this year, the Secretary General also commented that we are waging a war against the planet, a war that was senseless and suicidal. So in the context tonight, we're going to look at litigation and climate litigation, some of the cases that have happened over the last number of years. And it's personally a very interesting topic for me as someone who was involved in some of the early climate litigation cases in Australia that are now over 15 years ago. Cases like the Anvil Hill case, Gray and the Minister of Planning, Walker and the Minister of Planning, where in the New South Wales court, we got judgments that said that these were matters that were deadly serious that governments had to take into account. But over those last 15 years, Australia has doubled its coal exports and massively continued its commitment to fossil fuels, both coal and gas. So one can ask, has that promise of climate litigation been addressed and been made? And also, what of the future? So this evening, we're here with two great lawyers and personal friends. Briony Eales is a climate change and environmental lawyer working in the Asian Development Bank's Law and Policy Reform Program. She is currently the team leader for judicial capacity building for environment and climate change law. And during 2017 to 2020, Briony led detailed research into climate change law, policy and litigation in Asia and the Pacific. The Asian Development Bank published the results as a 4-part report series, Climate Change Coming Soon to a Court Near You. The reports discuss climate science, Asia and Pacific climate litigation, and regional and international climate law and policy. In her other work with ADB, Briony supported a Southeast Asia government with its climate law and climate change strategy update. We're also joined by Maria Cecilia de Sicangco. Cecilia is currently a senior legal officer at the Asian Development Bank. She works with development partners across Asia and the Pacific to promote the rule of law and establish an enabling environment for sustainable development. Cecilia is involved in the design, processing and implementation of the law and policy reform portfolio, which covers key areas such as environment and climate change law, gender-based violence and access to justice, commercial law and private sector development, digital economy and Islamic finance. Her work has been published in the Yearbook of International Environmental Law by Oxford University Press and the Human Rights Education in Asia Pacific Journal. She was a co-author with she authored the International Climate Change Legal Frameworks volume of the Climate Change Coming Soon to a Court Near You report series. And she also contributed to the National Climate Change Legal Frameworks volume, which synthesized the climate legal and policy framework of 32 countries in the region and analyzed key legislative trends and climate relevant constitutional rights. Cecilia is a Philippine and US qualified lawyer, admitted to the bar in the state of New York, and a certified public accountant. She is a member of the World Commission on Environmental Law, and it's a great pleasure to have you here both today. And the first thing we will do is we'll make sure we put the link to the report series, which are available on the ADB website. And I commend you for what is, I find, an extraordinary resource and is just well worth diving into for a whole range of issues. So first, can we move to the reports? Briony, Can you sort of tell us about the report series and what it contains?
All right. So, hi, everyone. It's a pleasure to be here tonight. So I will talk briefly about reports 1 and 2, and then Cecile can talk about reports 3 and 4. So I hope you can see this is report 1. But essentially, report 1 is really looking at the reasons why we did this report series. And they were in recognition that people around the world are turning to courts for relief for matters of life and death, and that judges and lawyers need resources to support them in the face of these new legal challenges. So with the reports, what we really wanted to do was show what climate litigation in Asia and the Pacific looks like. It has a unique flavor. It doesn't necessarily fit the mold of other areas of the world. And we also wanted to highlight some excellent jurisprudence that have come from courts across Asia and the Pacific, and share remedies that have been applied that could actually be used all around the world. And so report 1 also briefly discusses climate science, which was quite difficult to write, actually. I wrote the part on climate science. I'm not a climate scientist, but we took the view that lawyers actually need to get comfortable with what climate science is. So we need to get comfortable with the basic terminology and discussing it. And we also recognize that the IPCC reports, being the most influential and important reports about climate science, are also very detailed and technical. And sometimes lawyers and judges need entry points to help access that. So we've provided references for people to look at and basic explanations of terms. So that's report 1. Report 2 was really the jewel in the crown, we thought, about looking at climate litigation in Asia and the Pacific. And what we did with this report is we talked about climate litigation thematically. So we broke the report down into common types of lawsuits filed in the region. We didn't provide different country legal analyses. It's really this, what are the different courts claims that are brought, constitutional rights-based claims, reviews of EIA. We partnered with the Sabin Center for Climate Change Law in Columbia University. And the reason we did that is we got them to write about climate litigation that's happening in the rest of the world, while we focused on climate litigation in Asia and the Pacific. Now, something that was really important to us, as I mentioned, was to talk about what is an Asian and Pacific climate change case? And so that meant, what is the definition? What kinds of cases are we looking at? And we decided it was important to write about cases that explicitly talk about climate change, cases that mention it in passing, but also those kinds of cases that have co-benefits for climate action across Asia and the Pacific. And those kinds of cases that have co-benefits are frequently those cases that are about ecosystem protection, biodiversity protection, and restoration. And so the reports specifically look at adaptation litigation in the Asian and Pacific context, looking at protecting mangroves, flood zones, and glacier health. And so, yeah, that's something that was very important because nature-based solutions need to deserve more attention. And linking back to what Matthew was saying about COP, adaptation was more of a focus at COP26. However, climate finance for adaptation lags, as does litigation about adaptation. So it's important for us to start talking about what is a climate adaptation case so that lawyers can run better cases before courts. All right, Cecile, over to you for reports 3 and 4.
And I just wanted to, sorry, Cecilia, just to interrupt a little bit. I just also wanted to notice that I was listening to Jonas Rockström talking at COP26, where he highlighted the fundamental role of nature-based solutions in responding to climate change, but also made it quite clear that that shouldn't be considered as part of our need to reduce emissions or respond to mitigation or adaptation. It was a sort of an extra component on that. So I think that that's a really interesting angle that you've also adopted, that ecosystem-based litigation is really important and can actually have a really important role to play in climate change jurisprudence. So sorry, Cecilia.
Sorry, Cecilia. I just wanted to make a quick point on that. I think it's been really, for too long, climate change people have worked in silos from biodiversity protection. So that's why you've seen things like palm oil plantations spring up. So they were really touted. Palm oil was really touted as being a climate solution, but it had sort of very significant impacts on biodiversity across Asia and the Pacific. And so it's really important for us to start thinking about the different connections, that it's one planet, and that a healthy planet has a better chance of protecting us from climate change, but also we're part of it. So ecosystem health is important in and of itself. So sorry, Cecilia, I'll hand over to you.
No worries, no worries. Thanks, Briony. So Report 3 provides a holistic synthesis of the climate legal and policy frameworks of 32 countries in Asia and the Pacific. National frameworks are important and they're significant because they underpin international climate action. They're the backbone of domestic responses to the climate emergency. I think if there's anything we've learned from the last 10 years, it's that international climate change law and national climate change law have a mutually symbiotic and mutually reinforcing relationship. At the end of the day, we can only work in our own jurisdiction and within our own soil. So this massive cross-pollination across jurisdictions is why we conducted what I think is the heart of Report 3, which is a comparative constitutional analysis. So for all these 32 countries, we analyzed, I think, around 12 or 14 different rights, like the right to life, the right to biodiversity, the right to sustainable development, the right to environment, the right to water, etc. And then we took that using a climate lens and we tried to answer 3 questions. First, are these rights explicitly mentioned in the Constitution? And in the affirmative, where were they mentioned? Because if they were mentioned in the Bill of Rights, then you know that that's enforceable or executory against the government. Whereas if they were mentioned in the state principles and policies, then it's something that informs government action, but it's not necessarily self-executory. And then, but in the negative, assuming that they were not mentioned in the Constitution at all, were they nevertheless incorporated in the jurisprudence of that country? Have the courts in that country nevertheless inferred those rights in their jurisprudence? And then turning to Report 4, which I think is like the fraternal twin of Report 3. As I said, they have a mutual international climate law and national climate law have a mutually symbiotic relationship. So Report 4 talks about the nature of the Paris Agreement, its history, and the framework of international instruments and international legal principles that support global and domestic climate action. We look at multilateral environmental treaties, regional agreements, and rights-based instruments, and how these instruments impact climate litigation. I think also that the value added of our report is that we look at the procedural aspect as well, and how do you domesticate these international norms into the domestic legal framework? As you say, what will the cook do with the meat if that person doesn't know how to cook? So that Report 4 walks us through this roadmap of domestication, of how and when a state is bound. For example, if it's a dualist country and it has signed a treaty but has not yet ratified it, are there nevertheless rights emanating from signing? Are there other international norms outside of treaties and conventions that are applicable anyway, such as general principles of international law and customary norms? These are the kinds of questions that Report 4 answers. So I think from Reports 1 to 4, we tried to answer the entire sphere of what could what could interest climate litigators and judges adjudicating climate cases. And not to toot my own horn, but I think, the 4-part report series is very comprehensive and hopefully is something that's helpful to climate litigators and judges as well. Thanks, Matthew.
Thank you, Cecilia. And I'm very happy to praise this report because I have found it exceptionally useful. I mean, there are, I think, 1,200 pages of material there. So it's something you can dive into to really sort of, and I was just producing a recent report when we're looking at the role of procedural rights and constitutional rights in the Asia and the Pacific region. And because you've gone through that broad lens, and perhaps I can ask a question there, within that report and put volume 3, you've looked at a number of different constitutional rights. Why did you choose that? I mean, it would have been easy to say, is climate change in the Constitution? Yes, no. But instead, you've gone right into the details of to the right to life, right to health, children's rights, a range of different constitutional rights, some of which exist, some of which don't. I mean, it was why choose those sort of that broad brush, if you like?
Well, I think what's interesting about Asia and the Pacific is that there are a lot of progressive constitutions that mention, for example, the right to a healthy environment. I think Vietnam's constitution also has a right to sustainable development, etc. But there are also old constitutions that do not mention these things. So you have to give judges the tools to look at climate change from both like the granular perspective and from the broad perspective. So for example, India does not mention climate change, but it had the right to life. And the Indian judiciary used that in various environmental law cases and climate change cases to underpin their analysis. So I think it's important to give that human rights based approach, as well as, an analysis of whether or not these constitutions also mention, the quote newfangled principles like sustainable development goals, etc. Yeah.
And no doubt we'll get back to a bit of a discussion as to the some of the constitutions that may provide fertile ground for potential litigation. But also just focusing on that international regime, the Framework Convention on Climate Change was signed in 1992, along with the Convention on Biological Diversity. We've had the Kyoto Protocol, and then we've now had the Paris Agreement, all of which sit under the Framework Convention on Climate Change. One question is always, is the Paris Agreement enforceable? Are there parts of it that are enforceable, or is the Paris Agreement, like so many other agreements and or treaties, have to be implemented into domestic law? And does that vary by country within the region?
Well, I think the architecture of the Paris Agreement is that it's not, there are no penalties involved if the countries are not able to meet their NDCs. It's really a name and shame regime. But the important part about the Paris Agreement is that it gives the progressive, non-retro nature that the countries have to, each time they submit an NDC, it has to be something that's progressive over the last. And now, if you look at like the financial system now, even if there are no mandates, we have, I'm going to talk about this later on. We have like shareholder litigation. There is social pressure for countries to actually address climate change. So even if the Paris Agreement does not have penalties, that social pressure, it has that snowballing effect. Plus, we also have to look at the Paris Agreement in terms of how it relates to multilateral environmental treaties. So, for example, we have cases from South Asia that talk about the Paris Agreement vis-a-vis, let's say, the human rights treaties like ICCPR and ICESCR, which are, the rights of which are embedded in national constitutions. So the Paris Agreement, I feel, is not something that you take, in silo, or it's not something that you look at from this unilateral perspective, but how it interplays with the other international treaties, whether it's human rights based or multilateral environmental treaties, which have, their own way of being incorporated in domestic law.
So turning now to some of the cases, and I know you've spoken, at a number of forums on a number of different cases. So Briony, turning to you, in terms of some of those cases that you think are quite significant in the region, what's one that springs to mind, or one or two that spring to mind?
Well, just coming off the back of that discussion about the domestication of international treaty obligations, there was a recent decision this year in Bangladesh where the Bangladesh Environmental Lawyers Association sued the government in relation to illegal filling of sand in mangroves. And so it's not a direct application of the Paris Agreement, but it's relevant in the sense that what the court found was that the government had signed international treaties, and off the back of signing those international treaties within the law of Bangladesh, it had an obligation to implement those treaties and pass laws consistent with the Ramsar Convention, so protecting mangroves in Bangladesh. And so coming back to the point that I made at the top of this conversation about us taking a broader perspective on climate litigation, that is to say, mangroves are essentially important for both mitigation. They draw down very large amounts of carbon, but they also protect communities from storm surge, sea level rise. So that's how I'm treating that as a climate change perspective, a climate change case. I guess what makes the case quite interesting is the innovation that the court used. So, as well as saying, okay, we have these treaty obligations, we have a hole in our existing framework, we have an obligation to fill that hole and pass laws that are consistent with the Ramsar Convention. What the court did that was so interesting is that it also said, we can't address these issues until we educate the public. So the court required the Ministry of Education in Bangladesh to roll out very regular hour-long sessions for every student in Bangladesh to educate them about the importance of conserving wetlands, conserving mangroves, and linking that with climate change and the preservation of life. And it also directed the Judicial Training Academy to train future judges about mangroves and the importance of preserving them. So it's not strictly like an application of the Paris Agreement, but it shows this, this using a wider lens to understand what the domestic aspects are and what needs to be done to protect people within a country from the impacts of biodiversity collapse and also climate change.
And that Bila and Bangladesh case reminds me of some of the cases that MC Mehta used to run in India, and one of which was, he said, he took a case in the Indian Supreme Court which said precisely that in order to understand the importance of the environment to the right to life, you had to educate. And I think the court then ordered a series of slides be done before cinema, so before movies, and this was going back 20 years, so before the internet was widely used. And so that was also a way of promoting sort of the idea of environmental education and the issues, which I think gets back to your volume 1, trying to educate judges and lawyers on the science of climate change, which I think is transformative in many respects. Can I then, I want to also talk about a couple of interesting cases that we've heard a lot about, the Lagari and Pakistan case 2018 in Pakistan, and also the judgment on DJ Khan, which I'm just going to put in I think it's being in the chat box. So Cecile, did you want to start to talk about DJ Khan and someone take a look a bit about the Lagari case and what it was, and And then one other issue that I'd also like to explore a little bit later is how relevant are some of these cases to other jurisdictions in Asia and the Pacific? And we can deal with that a little bit later. But in terms of the DG Khan case, the cement case, and also the Lagari case,
okay,
would be
sure.
great to Cecilia.
DG Khan was written by one of whom I feel is one of the greatest judges of our time, Justice Syed Mansoor Ali Shah of the Supreme Court of Pakistan, and it was promulgated in April of this year. In that case, the Supreme Court of Pakistan upheld the decision of the government of Punjab, which is Pakistan's largest province, to ban the construction or expansion of cement plants in environmentally fragile zones. So a cement company had challenged that decision as allegedly being violative of their constitutional right to freedom of trade, business, and profession. But the Supreme Court disagreed and said that allowing cement plants to continue or to be constructed could further deplete groundwater and cause other harmful environmental impacts. So this case is an example of a court deciding a case with a climate lens. Climate change was not explicitly and directly pleaded by the parties, but the court underscored that climate change should be considered in government decisions. So the court went beyond the black letter of domestic law and referenced both well-entrenched and emerging principles in international environmental law. So it referenced the precautionary principle of Principle 10 of the Rio Declaration, but it also considered the emerging environmental law principle of in dubio pro natura, or in cases of doubt, all matters before courts shall be resolved in a way that is likely to favor the protection and conservation of the environment, with preference to be given to alternatives that are least harmful to the environment. Actions shall not be undertaken when their potential adverse impacts on the environment are disproportionate or excessive in relation to the benefits derived therefrom. Another emerging international environmental law principle that the court referred to was the personhood of the environment and other natural objects, meaning that they are holders of legal rights, independent of any right to be invoked by a citizen or by a human being. In fact, the court said the environment needs to be protected in its own right, and there is more to protecting nature than a human-centered rights regime. And the court referred to, we were talking about cross-pollination across jurisdictions earlier, and then the court referred to, legislatures and courts all over the world that have discussed this personhood of nature and natural objects. So the court referred to Ecuador, New Zealand, Australia, Uganda, Colombia, etc. And then another interesting principle that's emerging that the court referred to is the concept of water justice. It means that the courts and policymakers must consider the interlinkages between water and land and the ecological functions of water resources. So any person with a right or interest to use water resources or land has a duty to maintain the ecological functions and integrity of water resources and related ecosystems. So again, this is about looking at cases with a broader lens. And the court actually said that when you decide a water case, you have to have systems thinking. That's a term that I use, systems thinking, but it really means that you have to look at it from the perspective of how water interacts with other natural resources. And one should not decide cases on a sectoral way or on a sectoral fashion, but it requires a broader recognition that these resources are inherently ecological, political, and social issues simultaneously. Another thing that's very interesting about this decision is this concept of, they took into account the concept of intergenerational justice and introduced the principle of, quote, climate democracies. The court said post-climate change, democracies have to be redesigned and restructured to become more climate resilient. So this DG Khan case is interesting because it shows us what the next turn of climate litigation could be. How will it look like? how is the right of participation operationalized? What does this right include and require? So, these things, the court did not touch upon these deeper issues, but I expect that courts all over the world would be talking about or framing the issues from this perspective, in the coming years. Thanks, Matthew. I'll let Briony take Ligari.
Sure. And I'm also interested, Briony, in terms of this idea of some of the using of existing principles or well-defined, well-accepted principles, and some of these new emerging principles, because I think that's also where we've seen a lot of these climate litigation cases that have these other issues are very powerful, because they're also looking at new and emerging principles of environmental law that could be and probably are international environmental law principles.
Yeah, just on that point, before I move to Ligari, one of the points that I thought was really interesting about the use of constitutional litigation that relies on different rights is, I think it's important to understand that climate change impacts different rights. So you don't just have a right to a clean environment, you have a right to life, you have a right to food, you have a right to water, you have a right to an adequate standard of living. So I think what we're seeing in any jurisdiction is lawyers looking at the legal rights that are available in their jurisdiction and picking up on what they can use and saying, well, this is a case about water, so I don't necessarily need to say I've got a right to climate, you've got a right to water, and then you can connect that back to climate change. And I think this is what makes Ligari a fascinating decision, and there's good reason for it being so famous. It's the same judge that penned the DG Khan case. And it's a case where a farmer went to the High Court of Lahore and said, I have no water. Like, I'm a farmer and I have no water. And so then the case became connected with, okay, well, why is there no water? Well, it's an impact of climate change. And the court looked at environmental justice, but importantly, what is water justice and what is climate justice? And the reason climate justice is fascinating in this case is because the court said there is not necessarily a climate change case, because climate change could impact all of these different facets. And what is important is that courts are mindful of that. They watch for the issues that are coming into their court, and they understand, they look at things through a climate lens, or they have this level of climate consciousness. And so it's also an important case because it uses a writ of continuing mandamus to compel the government to do particular things. And the writ of continuing mandamus was pioneered in India, but it's been picked up by courts all across South Asia, and has also been picked up in the Philippines. And the idea is that the court holds the matter open on a rolling basis and requires the respondent, usually the government, to come back and provide regular updates, quarterly or biannually, to say, this is how we are going implementing these court orders. And that's actually a very important technique in Asia and the Pacific. You know, if you look at decisions in Germany or the Netherlands, the court makes the decision and the government implements it. And the same is not always the case in Asia and the Pacific, where the courts may need to micromanage a little more to see what's happening. But what was also fascinating is that the court said, under the Constitution, this is a constitutional writ petition, we have very broad powers, extraordinary powers to make a remedy that fits, that's a good solution. So what the court did was ordered the government to create, sorry, it didn't order it, it constituted a climate change commission. And the responsibility of this climate change commission was to ensure that the government implemented its existing climate change policy framework. And it appointed the members of that commission. So it wasn't just members of the government, although it did use ministers from all different ministries, but it also appointed experts to the commission to help guide the commission, which I think is really important. So it created this really wide and open perspective on what needed to happen, and it held the matter open, and it required the commission to continue to report until the government had achieved 66% of the priority items within the climate change legal framework, or the policy framework. So you can see why it was such a revolutionary case. I shouldn't say revolutionary, but innovative, in the sense that it understood the breadth and the complexity, and that an extraordinary remedy was needed in this particular case to make
Yeah. So can I just focus a little bit on that remedy, and sort of answers from both of you would be great, because from an Australian common law background, the power of the courts in many other countries is in some ways far greater, and the courts in Australia would be very reluctant to get involved in some form of continuing mandamus. I think that's the same in many other jurisdictions. But you mentioned that one of the things that courts can do is craft innovative remedies. Is that something that we're likely to see happen over the next, the next phase of climate litigation in Southeast Asia or South Asia?
Do you want?
Briony, you could start on Cecilia.
Yes, I think it's an extraordinary juncture in the world, and we will see more and more novel arguments, and we will see courts being open to applying the principles that are available to them and the remedies available to them to provide something that is fit for purpose. You may not see orders. The writ of mandamus is available in many jurisdictions. It's simply requiring a government to do its job, or a party to do its obligation. So I think the only thing that's different about the continuing mandamus is it holds the matter open and says, keep coming back and give us updates. That's available. And I think injunctions are available. And I think courts can start saying, okay, in dubia pro natura, in this case, we need to look at issuing an injunction because that's the best remedy. So I think we will see that.
Okay. And Cecile, your thoughts in terms of maybe Southeast Asia? Or?
Yes, I think courts are going to be looking at it from a broader perspective, and there will be unique orders coming. It's not just going to be like a Southeast Asia or a South Asia phenomenon, but like courts all over the world. Like I read about a judge in the US, and this is, I think, about a biodiversity, not about a hunting case. And then this person, the accused, hunted without a permit. And one of the things, so he was imprisoned, and one of the things that the judge ordered was that every day you are in court, you are required to watch Bambi, the cartoon. You don't usually like read something like that of judgments that come out, of those serious courts. But I think it just goes to show that the judges now are really more open to different remedies or different ways of handling things. I think it's also a function of the evolving nature of climate litigation. Like the cases that Briony and I discussed were against the government. But now I think, moving forward, we're going to see more and more cases against private corporations and private individuals. So, and it's not going to be the usual suspects of the activists, etc. We are seeing a slew of shareholder suits, and shareholder suits are super. They're very handy because they sidestep the question of standing. Because I'm a shareholder, therefore I have, the directors, the company, they have a fiduciary duty to me, even if I just hold one share. So so I think judges are starting to not just issue unique judgments, but they're also starting to see climate change come into their courts in different forms. So yeah.
Yeah. Okay, so then as the cases change, so too may the remedies and the consequences. And maybe that's a good place to talk about some of the recent cases in Australia, I think against Commonwealth Bank or other or superannuation funds. So Briony, did you want to just mention some of those cases?
Yeah, Australia's really leading the way in some of the corporate. Is my internet connection stable, by the way? Can you all hear me?
Yes.
I'm having extraordinary issues tonight, but yeah, Australia's presenting an interesting jurisdiction, and I think around corporate litigation, and I think it comes down to the fact that each jurisdiction has its preferences, and so corporate litigation is very popular in Australia, but a lot of these are around directors' duties of disclosure to their shareholders. So there's a case in Australia Abrahams is suing the Commonwealth Bank saying, I'm a shareholder. The Commonwealth Bank of Australia has invested in or lent money on fossil fuel projects, and it has an obligation now to report back to its shareholders on the risk that it's exposed to and how that risk ties in with its own ESG reporting. So that's one case. And then there's another case of Kata O'Donnell. She's suing the Commonwealth Government of Australia, and I'm just trying to find my notes on it because it's actually about misleading and deceptive conduct. So it's not about a duty of disclosure in this particular case. So the plaintiff bought government bonds, and she's saying, the Australian government has been misleading in representing the level of risk presented about climate change, and that's affecting the value of my investment. So there are different kinds of corporate litigation, and I think the lesson that we can learn from these different types of litigation is that each jurisdiction will use the type of law that lawyers are used to practicing and the body of law that's well developed. So just on that as well, Australia has some recent litigation in the matter of Sharma and the Minister for Environment in Australia, which is about the extension of a coal mine in New South Wales. And in that case, the plaintiffs, as a class suit, sued the government under the law of negligence. And so there's now, this is a recent decision of May of this year, finding that the Minister for Environment has, under the common law of negligence in Australia, an obligation, a duty not to cause harm to children when making a decision to extend a coal mine or not. So, you're just seeing different types of litigation. And I think the Australian context is probably a good context for Southeast Asia, where you are less likely to see the constitutional rights-based litigation in this region.
So, I think it's really interesting because on that question of obligation, and I think the Sharma case was a duty of care case, so it was essentially a tort of negligence, and we've seen in the Vedanta case in the UK and Opcapi where these are pollution cases from pollution caused in a number of African countries, but they were suing the head office based in London because that was where some of the assets were, about negligence and about whether or not the subsidiary company was liable because the head office was liable for the actions of the subsidiary company because the head office had an environmental policy that it said applied to all of its members, which I guess perhaps raises the issue of the recent Shell case in the Netherlands. I mean, the Netherlands, we've seen a couple of extraordinary case, the decision against the Dutch government to take further action to strengthen its climate change policies, but also the case against the Royal Dutch Shell Company, where the court, as I understand, held that the company had to do more than it had currently proposed in order to reduce its carbon emissions. I mean, is that Royal Dutch Shell case, is that likely to be a type of litigation that we're going to see in Southeast Asia, or is that something that was more relevant to the particular legal environment in the Netherlands. Cecile, did you want to comment on that?
I think that that's something that we could see not just in Southeast Asia, but across jurisdictions. There is a similar Shell case from Nigeria. Basically, it was a case by community citizens against the government and Shell Nigeria, and the issue was that the federal court said that the Shell must stop flaring gas in the Niger Delta because this is unconstitutional, as it violates the rights to life and dignity. So this case is I would say progressive, or some would say regressive, depends on which point of view. But I think it's progressive because it shows the extension of the constitutional right analysis, not just against governments, but also private institutions like Shell. Usually when we say that we have a fundamental constitutional right, it's a constraint against the state. But now we see that, that kind of thinking is that they call this, quote, the horizontal application of human rights. And I took a look at Nigeria's constitution to see if their constitution allowed or recognized breaches of constitutional rights by private parties. And from my study, I was not able to see a provision acknowledging that. So this court, this decision, shows you how constitutional analysis is now being applied even to private institutions. Just going back to our area of the world in the Pacific, there are several countries in the Pacific that specifically allow constitutional rights cases against private individuals and private companies. I think that's Papua New Guinea, Tuvalu, and Fiji and Kiribati. They don't have that in their constitution, but they have cases decided by the High Court that infer that constitutional rights could also be invoked against private companies. So these slew of cases against private companies is something that I see will not just the Dutch Shell case is not something out of the ordinary, but it really portends of the things to come.
And if I can just add to that, Matthew, just the reason why Shell, it's fascinating. So the argument was that given the Paris Agreement goals and scientific evidence about the dangers of climate change, that Shell had a duty of care to reduce its greenhouse gas emissions, and that the duty stems from articles under the European Convention on Human Rights. So it's similar to these constitutional rights, but also the Dutch Civil Code. The duty stemmed from the Dutch Civil Code informed by this Convention on Human Rights. And the court was also very aware that Shell knew of the dangers and had made misleading statements. But what the court found was that there was an unwritten standard of care laid down in the Dutch Civil Code. And I think that is what is transportable. The fact that the court said, okay, we have the Dutch Civil Code, it's informed by these rights that are available within the European Convention on Human Rights. So many countries have a civil law or a civil code that would be informed by the constitutional rights that are available within that jurisdiction. And then what the court did was it said, okay, we're taking the leap and we're saying there's an unwritten duty of care here, which says that Royal Dutch Shell, knowing of all the dangers, has this obligation to reduce its greenhouse gas emissions. And it has an obligation to reduce them for itself, all of its connected companies, and anyone who uses its products. And that's what's so broad about it. But just to connect it, quickly, there are decisions in Indonesia about peatland and forest fires, which are also looking at a duty of care of anyone that has a concession holders for peatland and forests, not to burn down peatland or trees. And so that there's litigation around that, which we cover in the report series. So you're just seeing the duty of care being applied in different jurisdictions differently, hanging on different legal rights, but I think many jurisdictions can pick up on it.
And that perhaps leads into a discussion about this recent air pollution case in Indonesia, the Subono and the president of Indonesia. And so, Cecilia, in terms, it seemed that this was also the type of case that, although focused on air quality, used some of this, what have you called it, the horizontal application of constitutional rights, or to other forms of environmental protection, perhaps air pollution, perhaps maybe sea mining, seabed mining, or deep seabed mining. Could you just explain a little bit about that case in Indonesia about the Jakarta air pollution?
Sure, Matthew. This was a case that was filed 2 years ago by 32 people who were living in the greater Jakarta area. And the objective of the suit was to compel the president of Indonesia and the Minister of Environment and Forestry, the Minister of Internal Affairs, the Minister of Health, and the governors of Jakarta and 2 other adjacent provinces to compel the authorities to take action against severe air pollution in Jakarta. They don't seek any financial compensation. They just wanted a stricter regime of supervision of environmental laws and standards, and sanctions for offenders. And the background of this is Jakarta's rapid urbanization and the traffic, along with nearby coal-fired power plants, have contributed to the poor air quality. And Greater Jakarta is home to about 30 million. So if it were its own country, it would be about the 48th most populous country in the world. And there were studies that the court that were given to the court that said that air pollution was reducing Jakarta residents' life expectancy by 5.5 years. So this case really was underpinned by how air pollution impacts the right to a clean environment, because there was scientific research that air pollution could cause conditions such as asthma, heart disease, and lower life expectancy. The Central Jakarta District Court, in a 3-0 ruling, said that the president, the ministers, and the 3 governors were guilty of environmental negligence. So it ordered the president to establish national air quality standards to protect human health, and not just human health, but the environment, ecosystems, including the health of sensitive populations, based on science and technology. So, with that short phrase, you actually, they actually covered a lot. They covered the right of not just right to health generally, but the more sensitive rights of vulnerable people. And it also, the decision was also underpinned by the reference to science and technology, which, as the Paris Agreement and the other multilateral environmental agreements also refer to science-based approaches. It also ordered the health minister and the Jakarta governor to devise strategies to control air pollutions. And there were also other measures discussed, for example, an analysis of cross-border emissions. And it also ordered that older vehicles must be periodically tested for emissions. This was a case that was decided by the district court, so it is now on appeal to a higher court. So we have not seen the end of this case, but I think it's interesting not only because it involved the president, but because of the far-reaching, the breadth of this case. However, we have to take this in context with criticism that the government of Indonesia received post COP26, because they were saying that the government of Indonesia is just paying lip service to climate change concerns, because apparently the government actually had raised its 2021 target of coal output from 550 million tons to 625 million tons, and the reasoning behind it was that ending deforestation by 2030 and cutting carbon emissions was unfair and at odds with the country's development plans. So still, from the countries in what we can call the global south, we see a broad spectrum of decisions. On the one hand, we have DG Khan, which looks at cases from a climate lens, and on the other, we have cases that we have very good cases implicating the highest people in the land, but you don't exactly know how to enforce that. Because of they feel that it's contrary to the policy and development goals of the country. So that's the age-old development versus environment dichotomy.
And undoubtedly, those issues of climate justice will probably be well litigated next year, because that issue of the common differentiated responsibility and obligations, but in the context of catastrophic climate change and one could almost say catastrophic air pollution and potential biodiversity collapse, one must sort of perhaps argue that these obligations are very real and present and irrelevant to a national obligation as well. So look, we have gone right over time because I think there's just been so much really exciting information. So just in terms of, in closing, can I ask you to sort of, in terms of prognostications, over the next maybe 1 year or 2 year, what do you think are some of the key areas where we're going to see this climate litigation or this horizontal application of climate rights, the climate change in the broad sense? Because I think that's also really exciting to sort of go beyond just, is it about greenhouse gas emissions, but is it about planetary health? Is it about ecosystem health? Is it about the right to a safe, clean environment, and also the right of environment intrinsically to have its own integrity and security? So, Briony, did you want to go first in terms of some prognostication for litigation?
Sure. I think what's really important in any jurisdiction is to really have a good sense of the climate science or the environmental science to understand what the impacts are and what they will continue to be. When these, we talk about these cases like they're everywhere. I think in much of Southeast Asia, they're still challenging cases to run. Courts are still concerned about the separation of powers and interfering with policy decisions, and how to incorporate climate science and how to accept that. And so I think we need very well-informed lawyers to be running cases and to go to court with good quality experts to help run the cases on very sound principles that resonate in your particular country. I think that's really critical. I think we will continue to see rights-based litigation in certain jurisdictions. The other form of litigation that's very popular from a climate perspective is environmental impact assessments. So challenging any coal-fired power plants. So those kind of leave it in the ground kind of arguments. And they really need to be put together well. And I think we will continue to see that litigation picking up. There will be more, the litigation that I talk about probably will still be run more with an environmental aspect to it. It may or may not mention climate change, and that's okay. It's about considering, are there co-benefits for this kind of litigation? In terms of the corporate litigation, I think that is probably something maybe 2 to 5 years. I wouldn't expect to see it next year, but let's watch and wait and see. Climate litigation is exploding globally, so I'm always surprised at the expanding number of cases that we're seeing.
Thanks. Cecilia, any further comment?
Well, if I will differ a bit from Briony, I think that really the next turn of climate litigation is going to be the private sector space, whether you're a fund manager, an asset manager, an investor, or a private company. Really watch that space, because I think that's going to explode in the next couple of years. For example, let me just refer just one last time to a case. It was McVeigh versus REST. That's the let me see, it's the Retail Employees Superannuation Trust. So the plaintiff there brought a lawsuit against the trustee of his retirement fund, and he argued that the fund or the trustee breached the fiduciary duties owed to him by failing to adequately consider climate risks. And now here's the rub. The plaintiff and Rest, they were able to reach a settlement before the trial was to begin. But this is the fascinating thing. Sometimes a non-win is a win, because when they settled, Rest agreed and acknowledged in a press release that climate change is a material, direct, and current financial risk to the superannuation fund across many risk categories, including investment, market, reputational, strategic, governance, and third-party risks. And to address this, Rest agreed to implement a net zero carbon footprint by 2050 and to comply with the disclosure requirements by the Task Force on Climate-related disclosures to ensure that investing climate disclosure and to publicly disclose portfolio holdings, among other commitments. So I feel that because shareholder litigation is really, it sidesteps a lot of the issues that usually attach to the classic climate change case, that this is something that could be used the world over to push for change, not just to like policies, but really private sector actions. So, really a non-win. Mark McVeigh did not win the case, but he really won that case.
And indeed, that's possibly the best place to leave in terms of...
On that, sorry, Matthew, that's just quickly, that exact point in Australia, there was just successive litigation against coal-fired power plants. Each case wasn't necessarily successful, but it upped the ante each time of what the investors had to do. And that shifted the market in terms of what insurers were willing to insure and what financiers were willing to lend for. So just to reiterate that point, it may not be the win you're hoping for, but it does add up over time. Sorry, Matthew.
No, I think absolutely fine. And look, thank you so much, both of you, Briony and Cecilia, for being with us today. Thank everyone for their questions and their comments. We haven't been able to get to them. So many cases, so much litigation. Let's do this again soon. I should also say that, as I said, as a litigator in 2007, running Australia's first climate change cases, we lost, but we won at first instance in the Land and Environment Court, where judges well-trained who understood the science and understood the urgency. And in the words of Justice Biscoe in the case of Walker and the Minister, he said, climate change is a deadly serious issue. It was one of those amusing phrases that created a little bit of tittering in the Court of Appeal, where we lost. But the consequences of that loss still transformed the way governments made decisions, because the governments knew it was a relevant consideration in their decision-making processes. And that has certainly transformed those decision-making. Doesn't necessarily mean they've decided against coal. That might be the next thing. But of course, the role of superannuation and financial investors, the opportunities for litigation are significant. But also this issue about the horizontal application of constitutional rights and how broadly we can do. And we've seen that at least in Jakarta in terms of the air pollution cases, but also in Bangladesh with the Bila case over wetlands and issues of water. Can I thank you very much indeed for the extraordinary in-depth knowledge you have, for the 4-volume report. And can I also invite anyone, litigators and otherwise, to acknowledge that climate change is coming to a court near you. Thank you so much for your participation tonight. And can I ask you to join us next Tuesday for our final Seeds of Justice broadcast for this year, which will look at environmental and human rights defenders, one of the important groups who are constantly making the fight to ensure that environment and climate change issues come before the court and before government. Briony and Cecilia, thank you so much indeed for your time. I really appreciate it. And thank you to our team, to Pum, to Colleen, to Paolo and to Rocky for your great support for all these webcasts and podcasts. Thank you very much, and good night to you all. Thanks, Cecilia.
Thank you.
Thanks very much.